my schedule, so I'm not going to go at breaking speed, but I'm going to expect perhaps that some of the work in relation to the details of the two-stage approach you do on your own. Okay, but first of all, let's talk about where we are in this course. We've looked at rights and obligations. For those of you who do not know what that's the prepare for the test, let's do this. The rights in the Bill of Rights and the obligations. Okay, so you know about the different kinds of rights, you know about respect, protect, promote, fulfill. Looking at first, second, third, why they are ranked, if they are ranked, what are the obligations. Then we distinguish between direct and indirect application versus horizontal application. And then we say if we talk about direct application, in the first instance, before one can take a matter to court, you have to assert standing. And that is up to there where you have to complete for the test. So you have 3 questions. If I'm not mistaken, 20 marks, 45 minutes, easy peasy, lemon squeezy, 2 straightforward questions and 1 lovely application question. Because that is what you do. Okay. Then, what we are going to do today is we're going to look at, we're taking our direct application further. And we're saying, okay, now we have this, what and how are we going to proceed from here? Okay, so that's where we are today. And what the two-stage approach basically is a litigation strategy. What am I going to do? How am I going to go about to convince the court of the particular case that I would like to make out in this particular manner? Okay, and then after that, we're going to look at specific rights. And that is typically what would keep us busy for the remainder of the year. But as I say, we are a little bit behind schedule. And we're going to look at the two-stage approach. I actually have a detailed set of slides elaborating on the different steps in the two-stage approach before we move on to specific rights. So we're going to look at constitutional analysis and we're going to look at the interpretation. And the reason why we're going to look at interpretation of the Bill of Rights is because that is the first stage of the analysis. But that first stage of the analysis, we have to engage in very particular or not engage, we have to bear in mind particular constitutional provisions that are relevant in relation to interpretation. Now, the first thing that we have to bear in mind when we talk about direct application in the two-stage approach, not a single right that anyone has is absolute in its function. We all have rights given to us in terms of the Bill of Rights because we are human beings. They stem from international law, they stem from natural law theory, if that is what works for you. But the reality is, the right that you have, any right that you have, inclusive of your right to dignity, inclusive of your right to life, that right is not absolute. What do I mean if I say that? Government, the state, the legislature, through passing of laws, may justifiably limit our rights. But sometimes they limit our rights in such a way that basically erodes the right or that leads to a situation where the burden imposed by the limitation exceeds the benefit of the protection of the law that they try to enact. So it's very important that when we engage in this analysis, we ask ourselves, how far can the state go in limiting our rights? And that is essentially what the two-stage approach is about. Now, the case of Regina versus Oakes is a Canadian case of 1986, but it is the case that sets the basis for the approach followed in South African Constitution. And it is a very significant case for us to look at and to understand why we follow a two-stage approach. And we follow a two-stage approach which is to be contrasted with a one-stage approach. But let's look at the two-stage approach. Two-stage approach in the first instance say that we have to interpret, and then once we've interpreted, we engage in a separate analysis regarding limitation. And that limitations analysis determines whether we have an infringement or a justifiable limitation. Let me illustrate with the case of Mr. Oakes. So Mr. Oakes was caught with, I think 8, let me just make sure, I think it was 8 or 10, I can't recall, it doesn't really matter, vials of hashish oil. I'm quite sure he wanted to do something with it. But he was in this process of being prosecuted. The Canadian Criminal Code said, if you have a lot, 8 or more, vials of this particular drug in your possession, you are presumed to be a dealer. So if you are caught with drugs on your person and they are for your own use, you are caught in possession. And the penalty that you may get is X. If you are caught with truckloads of drugs, you are presumed, in accordance with this legal presumption created in the statute, you are presumed to be a dealer unless you prove that you are not a dealer. Okay? So what the legislation does is it says, Mr. Oakes and other guys like you, if you are found with more than X drugs, unless you convince us, you are liable to the severe penalty. A penalty that is more severe than just a conviction for possession. So Mr. Oakes says, hey, guys, wait. In terms of the Canadian Charter of Rights, I have the right to be presumed innocent. And the right to be presumed innocent includes that every aspect of the criminal charge against me must be proved by the state beyond a reasonable doubt. I had this for my personal use. I was not selling any of this. This was for me. So in other words, if I were to be convicted, I shouldn't get the penalty for trafficking. I should simply get the penalty for being in possession. So what does the Canadian court say in this particular instance? It says our Bill of Rights, our Charter of Rights, says everyone has rights, and the rights may only be limited in a justifiable manner in terms of the law of general application. So in the first instance, we have to ask ourselves, what is the right, and I was actually struck by how well the court put this, what does the right to be presumed innocent entails? Why do we have this right? The court says the presumption of innocence protects the fundamental liberty and human dignity of any and every person accused by the state of criminal conduct. This is paragraph 29. An individual charged with a criminal offence faces grave social and personal consequences, including potential loss of physical liberty, subjection to social stigma, and ostracism from the community, as well as other social, psychological, and economic harms. In the light of the gravity of these consequences, the presumption of innocence is critical. It ensures that until the state proves an accused guilt beyond all reasonable doubt, he or she is innocent. The presumption of innocence confirms our faith in humankind. It reflects our belief that individuals are decent and law-abiding members of the community until proven otherwise. So the court says quite clearly in this particular instance, this legislation that places a burden on Mr. Oakes to prove that he is not a dealer, clearly that has implications for his right to be presumed innocent. Now we have to ask ourselves, in a society such as ours, is it acceptable for the state to expect someone to prove their innocence? And the court says that is not acceptable. But the first stage requires us to determine what is the meaning of the presumption of innocence? Why does it exist? What is the impact of legislation shifting a burden? And then in the second instance, is that justifiable? And in this particular case, the court found that the shifting of the burden of proof to the accused was unjustifiable and unconstitutional. And subsequently in South Africa, we've seen all our cases or all our statutes that placed a burden on the accused to prove anything, that those have been declared unconstitutional. So if you are found with 200 grams of dagga in your possession, and you could be a dealer, Or if you're found with 20 kilograms, you could be a dealer. But the reality is the state must prove that. You don't have to prove anything. You don't have to prove yourself to be innocent or prove yourself not to be a dealer. The state has to prove that. Because legislation that shifts a burden onto the person who stands accused is unconstitutional. Okay, so this is to be contrasted with a one-stage approach followed in the United States and in Germany. The one-stage approach says, let's interpret and limit all at the same time. What is the right to freedom of expression or free speech? What does it include? What does it exclude? And we do that in one fell swoop. We don't ask, what does it mean? Does this legislation have an implication for the right? Is that implication justifiable? In one simple analysis, we say, what does the right mean, and how do we determine whether this limitation is acceptable or not? So it's a very different way of engaging with the process, the litigation strategy that you will set up for your client as you go through Bill of Rights litigation. So it's important to distinguish between a single-stage approach and a two-stage approach. Now, every now and then, the court does us a huge favor, and the favor was done a long time ago, in 2002, by Judge Crickler in the case of Walters. And he tells us exactly what the two-stage approach entails. He says, in stage one, which is the interpretation stage, we determine the content and the scope of the relevant protected rights. What does the right to be presumed innocent? What does it mean? What is in there? Why is it there? What is in there? What is the extent of what it covers? And then he says, the second part of the first stage is you look at the legislation. The impugned enactment is the piece of legislation or the piece of the common law or the part of the common law that you challenge as unconstitutional, as limiting justifiably or unjustifiably the right in question. Then you look at the meaning and the effect of the impugned enactment to see whether there's any limitation or impact of the limiting enactment or the impugned enactment on the content and the scope of the relevant right. Now take this back to Mr. Oakes. The right to be presumed innocent. This is what it protects. A burden of proof shifted. What implication does it have for the right to be presumed innocent? Clearly, it cuts into the right. But because we said right at the beginning that all rights may be limited, we then have to engage in the second stage. And we'll get to the second stage now. I just want to footnote this. You have done legal interpretation. As part of your consideration of legal interpretation, did you look at constitutional interpretation? What does that mean? Yes, no, all together at the same time? You've looked at the literal approach to interpretation. Purpose of? What is the purpose of it? Remind me. Why is this particular provision enacted? What is the core value that it aims to protect? Generous? We are the world, we are the children. Contextual? You have to take into consideration the textual, contextual, and the socio-economic and political, historical contextual. Go back to your Curry de Waal if you worry about that. Have a nice little exposition of what each of these different approaches to interpretation. On the slides that I have, setting this up in more detail, I will explain. But what I want you to get at this point in time is the following. We need to determine what is in the act, or what does the right protect? If that is the scope of the right, what does it protect? And then we have to look at the enactment, the legislation that we challenge, and we have to ask ourselves, does it actually shadow any part of this right? Does it impact on any part of this right? And then in the limitations analysis, the second analysis, Judge Crickler summarizes it really well. He says, we have to determine is justifiable, and we do that by engaging in a proportionality analysis. He says, in essence, this requires a weighing up, that is the proportionality analysis, of the nature and the importance of the rights, together with the extent of limitation against the importance and the purpose of the limiting enactment. Let's look at this, and we graphically set this out. So this part, where we now determined that this, this has, there's a little flaw in the board, that this has implications for the right. We have to look at this in the following way. We have to look at the nature and the importance of the right, plus the extent of the limitation. So we look at this right. How important is it? What is the nature of the right? Then we look at the extent of the limitation. How far does this cut into the right? And we weigh it up, put it in the scales of justice. We weigh it up against the importance and the purpose of the limiting enactment. Why is this here? What is the purpose that it is meant to serve? Okay, does that make sense? So you engage in an analysis where you say, how far does this enactment eat into the right? How important is the purpose that that serves in our open and democratic society based on freedom, dignity, and equality? Okay, so the first stage is, what does this include? The second part of the first stage is, what is the impact of the enactment on the right? And then stage 2, and obviously stage 2 only comes into play if there is an implication of the limiting enactment or the impugned enactment on the right. So, for example, if I go to court and I say, my right to freedom of speech is limited by, freedom of expression is limited by a statute that says, I don't know, I have to pay tax or whatever the case may be. There must be a link between the enactment and the right. If there's no link between the enactment and the right, you're never going to get to a point where you say the enactment eats into the right. And whether you have to ask the question then, whether that is justifiable in terms of the provisions of the Constitution. Okay. So constitutional interpretation, that first stage, you know about statutory interpretation, and your statutory interpretation will come in here where you determine whether this enactment, what is the meaning and the effect of a particular enactment. And as I've said earlier on, we've looked at these approaches, literal, purposive, generous, contextual, and incontextual, and historically contextual and textually contextual. And we will look at this, and if we don't have time to look at this, I will ask you, and I'm asking you now, please go and have a look at what Curry and Duval say about these different approaches to constitutional interpretation. Now, the Constitution does more than just refer to interpretation, the Constitution does very little but refer to interpretation in very few circumstances. It refers to interpretation only here in section 39 and in one or two other sections of the Constitution. And that is why we have to know the literal, purposive, generous, contextual interpretation of the Constitution, those approaches. Because those approaches have been set out in precedent, and we know when the Constitutional Court engages in the interpretation of the Constitution, they do so utilizing any of those interpretative approaches. But we also know that all of those approaches bring some value. Because we can't ignore the text of the Constitution. We can't say, well, that's the literal meaning. It says blue, but we're going to read it to mean red. We can't ignore the text, but we have to look beyond the mere text and look at the purpose, the context,
context, what it is intended to do, and determine the meaning of a provision in that way. But then there are also explicit provisions relating to interpretation. And these the explicit provisions are set out in section 39 for a start. Now, one of the things that we have to bear in mind is that the Constitution envisions its interpretation, and particularly the interpretation of the Bill of Rights, in an abstract and ideal society. And this underpins, once again, this notion of a two-stage approach. Look here. When interpreting the Bill of Rights, a court, tribunal, or forum must promote the values that underlie an open and democratic society based on human dignity, equality, and freedom. So when the court interprets the Bill of Rights, it doesn't necessarily have to contextualize it to the nth. Because if it contextualizes, and this is the challenge with a contextual approach to interpretation, you tend to limit at the same time. Because you look at how hard it is, how unequal our society is, how terrible the circumstances of many people, and you don't look at the values that underpin an open and democratic society. When you engage in determination of the scope and the content of the right, Section 39(1) says, what are the values of that ideal society? And how does it inform our understanding of the particular constitutional provision? And if you are wanting to think of a comparator of another kind of legal analysis in which this is used, this is when we determine the boni mores in accordance, or when we engage the law of dealing, for example, or the law of contract. So in the first instance, what we have to bear in mind is that 1A, stage 1A, the interpretation of the right in question, we have to look at the values of an open and democratic society. Those values, freedom, dignity, equality, section 1 of the Constitution, as we've discussed it in the previous part of our constitutional considerations. But section 39 goes on to say the following. The court must consider international law. Must. Now, what is international law again? International law is the law that regulates relationships between states. And as we've discussed in the first part of, or in Constitutional Law A, at some point there was a realization, well, yes, fair enough, we can make agreements about trade, it's very important. But we actually also have to concern ourselves with how states treat their own citizens. We can't just say, well, South Africa, there you go. Discriminate all that you want on the basis of race, because it's okay, because it's your own business. The world community said, it's not your own business. We have a standard that eradicates and, in fact, criminalizes a system which systematically discriminates on the basis of race. Okay, so that international standard exists as a standard particularly binding in relation to human rights. And here we have a constitutional injunction that says when we interpret the rights, when we engage in this process of determining the scope and the meaning of the right, we must look at what international law says about that particular right. We can't ignore it. Okay? So, we have to look at binding and non-binding public international law. So when, for example, we have to determine the meaning and the scope of the right to free expression, we have to look at conventions. Are there any conventions? And what do we mean when we say conventions in this particular instance? We talk about treaties. We talk about international law agreements typically facilitated by the United Nations. That says, in respect of freedom of speech or freedom of expression, this is the international standard. We protect this to that extent, but we don't protect that. And in making sense for ourselves as to what it means, we have to refer to international law. We must, the section of the Constitution says. So we look at treaties, we look at custom, we look at the general principles of law recognized by civilized nations, and we look at judicial decisions. So when you look at what potentially could influence our understanding of rights, you can see that there are a whole host of things. Apart from our own constitutional approaches to interpreting rights, we also have to look at international law. We don't have a choice, we must. Okay, yes?
Is there any instance where our law contradicts with international law? And what would happen if there was an instance like that?
If there is a contradiction, and there's not a contradiction, but there's an emphasis difference. In the case of the International Covenant on Economic, Social, and Cultural Rights, it says everyone has the right to adequate housing. Okay? Our Constitution says everyone has the right of access to housing. Can you hear that there's a difference? Because having access to housing could mean physical access, it could mean financial access, it could mean a whole host of things. But it means that I cannot go, if I don't have a home, go to the municipality or the provincial government or the national government and say, okay, you need to give me a house. They need to facilitate a process to enable me. That's what the South African Constitution says. International law can be interpreted to place a direct obligation. But international law also creates scope to say that it is within the purview of a state to determine what is affordable and what is not affordable. So in that particular instance, in Grootboom's case, the court says, this is what the international law says, this is what South African law says, we are directly bound by South African law. We take cognizance of that, because remember here, must consider, not must apply, must consider. Okay, but that's a well picked up point. Okay, but it may consider foreign law. So we are obliged in determining what is the meaning and the scope of our right of access to housing. We have to look at international law. And if necessary, we have to make that distinction between what does international law say and what does South African law say. But we also may consider foreign law. And what do we mean when we talk about foreign law? It is the law as it is applied and interpreted in Botswana, applied and interpreted in Canada, in Australia, in the United Kingdom, in the wherever. That is foreign law, the law of other countries. And what you will see, particularly if you look at the older judgments of the Constitutional Court, as the court was embarking on the building of an own jurisprudence, many times those judgments read like a comparative analysis. And in Germany the law is this, and in Namibia the law is that, and in Australia the law is this, and in this the law is that. Our text of our Constitution says this. If we interpret it in this way and that way, we come to the conclusion that this is what it means. And particularly, as I say, as the court was finding its feet, as you go through the judgments now, you will see there are newer judgments. There are references to the law as it is in Botswana, the law as it is in other parts of the world. But you will not see as much of it, because to some extent, after almost 30 years of existence, the court, or 20-odd years of existence, the court has established somewhat of an own jurisprudence, which it refers to back quite often. Now, Makanyane explicitly acknowledged that we don't need to do everything ourselves for the first time as if there's no framework to compare. But the difference here is we have to bear in mind, and this is what Judge Griffith said in Sanderson's case, there are textual differences and there are societal differences. Because a particular provision means X in Australia, and it has this particular scope, the comparable provision in the South African Constitution does not necessarily mean exactly the same. We can look at what the law says in Canada and Germany and in the United States. But we have to bear in mind our textual and contextual differences. So it's helpful, but it's not the panacea. It's not the resolution of all our interpretative challenges. We have to consider it, or we may consider it rather, but we have to consider international law in determining the meaning and the scope of a particular provision. Okay. What else do we have in the Constitution about interpretation? We have the preamble of the Constitution. And in Mkhuluka's case, paragraph 112, Judge Sachs said the following. The preamble in particular should not be dismissed as a mere aspirational and throat-clearing exercise of little interpretative value. It connects up, it reinforces and underlies all of the text that follows. It helps establish the basic design of the Constitution and indicate its fundamental purposes. Now, the important thing that we have to take from there is, when we try to establish what is the meaning of freedom of expression in the South African constitutional framework, what does it mean? Judge Sachs says we can refer to the preamble of the Constitution in trying to make sense of the meaning. What do we do with the preamble in ordinary legislative interpretation? How important is it to consider the preamble of the Income Tax Act in making sense of the Income Tax Act? As a general rule, we just ignore preambles. It is only in instances of ambiguity that we may turn to the preamble. But Judge Sachs tells us that a constitutional preamble is different. A constitutional preamble is not a throat-clearing exercise. It is something that does a little bit more than just merely introduce the piece of legislation. So we may refer to the preamble because it connects up, reinforces, and underlines the text that follows. Okay. We also have definitions set out in section 239. So chapter 14 of the Constitution, 239, contains certain definitions, and those definitions are important. It tells us, for example, what an organ of state is, what national legislation is, what provincial legislation is. And in some instances, where a particular constitutional provision uses a particular phrase, we can find the definition of the phrase in the Constitution. Section 240, on the other hand, tells us where there is a conflict between the different language versions of the Constitution, the English text will prevail. We know that the Constitution exists in 11 versions, official versions, but we also know that sometimes things get lost in translation. And that is when we consider, for example, that the English text may be slightly different, or there may be some seeming contradiction between the Isxhosa text and the English text. Section 240 says, then we rely on the English text of the Constitution. Okay. Now, I want you to bear in mind an example. And this is where you have to think about what the two-stage approach means. Parliament passes an act to regulate human stem cell research. The impact of the legislation will effectively shut down projects that are currently underway and jeopardize research and funding opportunities for many researchers in South Africa. Professor XYZ and a research team approach you for advice as they believe that several of their rights are infringed by the legislation. They wish to know what legal recourse is available. What will you say? How will you go about thinking about your two-stage litigation strategy? Where would you start? Yes?
I would look at like what rights are in question.
Absolutely. That is exactly where you would start. So you would say, okay, what rights are in question? From the top of your head, I know we haven't looked at specific rights, but do you think, what rights do you think could possibly be at stake? What about section 16? Does anyone have a constitution here? 16(1)(d), I think. You can read that. Can you read it out loud for us?
Academic freedom and freedom of scientific research.
Okay. So now you have to ask yourself, what does that mean? What does academic freedom and freedom of scientific research, what does the right to free expression mean in that context? What does it protect? And if the government, that is stage 1A, you have to interpret the meaning and the scope. I think one could perhaps add a stretch, add section 22. What does section 22 say? Freedom of trade, occupation, and profession. So basically, what they are telling you is, we don't have a job because we are stem cell researchers. That's what we do, human stem cell researchers. And if we are regulated to the nth, we won't be able to do our jobs. So then you have to say, what does that mean? What does it mean to have the freedom to choose your own profession? Because you know that at the moment, we have a law that says you cannot choose to be a prostitute. That's the oldest profession. I don't know why they call it a profession. Perhaps it should be an occupation. I don't know. But profession sounds quite professional. But okay, so we have a law that says you can be an electrician, you can be a plumber, you can be an academic, you can be a lawyer, you can be a this, you can be a that, but you can't be a prostitute or a pimp. That's one of those are things. Can you see that? The legislature said, choose what you want to choose, but don't choose that. You're not allowed to choose that. And in Jordan's case, the court had to ask the question, does it impact on people's right to perform the job of their choice? The court didn't deal with that argument particularly well, but that was actually something that they should have considered more seriously. Is it okay for the state to say to me, you can't be a prostitute? Or is it an illegitimate limitation of my right? Okay, let's move away from the more sordid and deal with human stem cell research, which could possibly also be sordid. So, does it have an implication for their rights under Section 16 and Section 22? I think we can arguably say yes. So, the enactment eats into their right. Now we have to ask ourselves, the nature and the importance of the right and the extent of the limitation. How far does this go? Does it say you cannot harvest stem cells from human embryos that were aborted or that were particularly created for that purpose? Or what does it actually say? The purpose of the limitation and the enactment. Why do they want to regulate this? And you have to weigh it up. I mean, obviously, this is the type of question that will require a hell of a lot of expert evidence. But what I want you to engage in the thinking process is, start with which rights are the rights in question? What do they mean? What do they protect? This enactment that says you may not conduct human stem cell research, does it have an implication for those rights? And that's your first stage. And then your second stage is, that implication that it has, does it amount to a justifiable limitation, or is it an unjustifiable infringement? And I want you to use those two terms as distinguishing what is acceptable constitutionally and what is not acceptable constitutionally. An infringement is an infringement. It is a negative thing. We don't like infringements. But a justifiable limitation says, you may do what you want to do, but actually just don't be a prostitute. Okay? Or don't kill babies to reap their stem cells so that you can grow ears on mice. Just don't do that. Or new organs, or whatever the case may be. Okay, so what you will have to do in this instance is, in the first instance, depending on the question, here I made it deliberately very vague. I said advise. Typically in the exam I will say, advise them as to the legal position in respect of with the right to freedom of expression, something more particular. But I wanted you to think of the different rights in question here. But you will first start with standing. Because remember, we're talking about direct application, and you will say, who has standing in this particular instance, and on what basis? I think we can very safely say Professor XYZ, she has standing, and her own rights are at stake. So we don't have to go to public interest, or to groups, or to associations, but we could. But very simply, we need to say, there are rights in the Bill of Rights at stake. She has a sufficient interest in the remedy of the declaration of invalidity that she seeks. Okay. So you have to interpret the rights in question to determine whether the impugned provision has an impact on the right. Does it eat into the right? And then once you've done that, you engage in the balancing exercise to say, is it an infringement or a justifiable limitation? Does this make sense? Okay. Then we'll pick up here. I'll see you tonight at 6. Fun and games. And then I'll see you tomorrow morning bright and early so that we can actually unpack this in a little bit more. Particularly when it comes to the limitations analysis. I really wanted to have a close